Hey, good afternoon. Thank you for joining us for ATARC's Insider Risk Working Group webinar. My name is Jameson Mitchell of the Centers for Disease Control and Prevention's Counterintelligence and Counter Insider Threat Program. Today, we're discussing legal and privacy aspects of Insider Risk Program. The views and opinions expressed today are those of the panelists and may not necessarily reflect that of the Department of Defense or the United States government. We are fortunate to have two key stakeholders in a successful Insider Threat Program. Legal, working with security to ensure the program has the right guardrails to enforce compliance, privacy, and scope of the program, and remain within the framework prescribed by the leadership and share it with the workforce. This is a foundational alignment, and oversight supports the building trust critical to any successful Insider Threat Program. I'm joined today by Rob Juge and John Massey. Rob, John, if you guys want to introduce yourself, and then we'll jump over to questions.
Hey, good afternoon or good morning, depending on where you are called in from today. My name is John Massey. I am the Department of the Air Force Counter Insider Threat Hub Director based out of San Antonio, Texas. And I'm joined today by my attorney, Rob Juge. Rob, over to you.
Hey, good morning, everyone. And as John said, I'm the attorney from the Air Force Office of General Counsel that is assigned and kind of forward embedded in the hub. It's a pretty unique concept because you put a senior level half attorney inside of an operational unit like the Insider Threat Hub, and it's neat to see what you can do.
Perfect, thank you. For insider risk programs, what are the policies and boundaries set forth by law?
That's a great question. I mean, for starters, it depends on what your organization is. Obviously, if you're a federal government agency, it's going to be a little bit different than if you're a state agency or if you're industry. I guess the center of it all is privacy. What does a person have a legitimate right to privacy in? Information that's publicly available, information that's provided by the employee with consent, or information that's otherwise in the government's hand, like a payroll record or human resources record. All of those information, or all of those pieces of information are fair game for an insider threat program to look at. For governments, including states and subdivisions, we look to the Constitution and a fundamental right to privacy that's found in several other rights. Generally speaking, without a warrant, the government can't invade your privacy. For executive branch insider threat organizations, we derive our authority from the Constitution and the President's Article 2 authority that he's exercised pursuant to, or not pursuant, but through Executive Order 13587. We see other implementing regulations, either through the Department of Defense, through other agencies. All that we do really is done within the confines of the Privacy Act, pursuant to a system of records notice and a privacy impact assessment. States sometimes have to worry about HIPAA and other state-specific laws, though most of the time, at least the 8 states that have privacy-specific laws on the books now are all focused in privacy in the consumer context, so they really don't come into play here. For us and the DoD, HIPAA could potentially come into play with medical data, but we certainly, or at least we currently, don't access any information from covered providers where HIPAA would come into play. So it's really all about the Privacy Act. Over to you, John.
Hey, thanks, Rob. I'll just piggyback on that. So in a previous role in my career, I worked very closely with defense industry, and specifically cleared defense industry and cleared academia. And they also are required to adhere to policies and laws that are put into place. And there used to be a manual, the National Industrial Security Program Operating Manual, or the NISPOM, and that's rolled up under Change 2 requirements now. But that's really the guidebook for cleared industry as well as cleared academia, looking at what are those 6 requirements with respect to insider threat programs in industry, and everything from establishing your program and appointing an insider threat program senior official to putting protection measures in place specifically on classified networks. So depending on the sector that you work in, whether it be government, industry, academia, there are a lot of policies and boundaries that are kind of set forth out there that we encourage you to explore and research and take a look at to determine, what do you adhere to? What do you have to fall under when it comes to building and maturing your program?
That's perfect. So I guess following in that same vein, how do you balance the need for insider risk professionals to do the mission while maintaining public trust and ensuring that you're doing the right thing?
Yeah, and that's really it. It's really a question of ethics. You know, who we should collect information on, what we should collect. We're constantly in tension, balancing the need to protect our organization and the government, like national security, against the need to withstand public scrutiny. Everyone's heard of the Washington Post test. Eventually, the information and what we do is going to come to light, even if it's classified. It's going to make its way into the public sphere, and we have to maintain that public trust. So we have to make sure that what we're doing can withstand that. Great example, like what information can we collect, like who we can collect information about. At least for DoD, with the FY17 NDAA expanded the scope of our covered population to anyone who has or had access to a military installation, or anyone who has or had access to classified information. I don't know about anyone in the room, but I get some heartburn realizing that an insider could be a dependent child of a contractor who worked for the DoD for 5 months 6 years ago, because that person had access to an installation. Even though we can do something doesn't mean we should do something. We should not be treating that 6-year-old dependent child as an insider threat risk and looking at their social media, even if it might fall in line with the law. I like to look at this as a test: can I, may I, and should I? It's almost the test for ethical decision making. If you can do something, do you have the resources and capabilities? If you don't have the resources or capabilities, you stop there. May I does the law allow you to do that? If you've got the resources, capabilities, and the law allows you to do it, you can go forth and do it. But should you be doing something? Would it survive that Washington Post scrutiny? And if it can't, then you shouldn't go for it. Another great topic when we're talking about balancing ethics is what information should we collect? Our insider threat program and other insider threat programs are constantly in battle over what information they should collect. Is a post on Facebook or some other platform that a person is holding a glass of wine? Should we be collecting that information? Is it overly prejudicial? Well, it depends. If the person is under investigation for an unpaid debt 10 years ago, probably not. What if that person is under investigation for a DUI and coming into work drunk? At that point, it might become relevant. So in order to withstand kind of the public test and really the Privacy Act, anything that we collect must be relevant to an insider threat concern. Otherwise, we shouldn't be collecting.
Yeah, and Rob, I'll touch on that as well. The insider threat and the insider risk mission space has evolved significantly in the last decade. We think about where we were 10 years ago, not too far removed from the executive order that was signed that required these programs to be stood up. And a lot of people looking at each other, trying to figure out where to begin and what they needed to do. And we've seen several significant high-profile events that have occurred over the last decade that have constantly resulted in a shift or a change in direction with new requirements or expansion of the mission scope that the practitioners and the operators then have to figure out how they do that and what's the proper way to execute, specifically adhering to the policies, the authorities, and the regulations. Sometimes that's a gray area when we first begin. We hear about something that's coming down the pipeline and we're trying to figure out, what does this mean and how do we do it? We want to be deliberate with rolling out new requirements. Take our time, be methodical, make sure that we're getting it right. I appreciate Rob's test that he just provided an example of, but also ensuring that everything that we do, it's legal, it's moral, and it's ethical as well. And when you're working in a mission space or a mission environment with perhaps limited resources or capabilities, you also have to take a risk-based approach. So as Rob mentioned, the 6-year-old, we're not going to focus on that, but let's instead focus on what's the core of the mission. Let's kind of get back to the basics, so to speak, and ensure that we're most effectively utilizing the resources that we're able to based on the highest level of risk, the highest level of threat, and also within the confines of policies, laws, and regulations that we have to adhere to.
John, that's a perfect comment and a nice segue. When you talk about focus, why is it more important to focus on indicators of risky behavior rather than ideologies?
That's interesting. So we, well, one, because it doesn't make sense otherwise, really it's a feasibility question. How would we get after someone's ideologies inside of their head? We really focus on the behavior because, you know, there's a general criminal law principle even that in order for a person to commit a crime, there has to be a mens rea and an actus reus. You know, you have to have the criminal intent and the criminal activity. Now, I don't know that there's much of a difference for us in practice because we do prohibit certain ideologies once they've acted upon. So as a great example, you know, however repugnant it might be, a person may have an idea in their head that certain races are inferior to others. We can't prohibit that because they haven't done anything wrong. Now, as soon as that person goes to a KKK rally and participates or pays dues to the KKK, even if they're a member of the KKK, as long as they're not paying dues to them, it's not something that we can generally prohibit. Thankfully, with most of the folks that do have these violent extremist type ideologies, they've taken some other action in furtherance of that, like supported the group, so we can really regulate it that way.
Yeah, and to piggyback on that, Rob, think about all of the high-profile, major visibility cases, insider threat events that have occurred in recent years. Everything from Major Nadal Hassan down at Fort Hood, Texas, to Manning, Snowden, and the most recent event that just occurred a few months ago. We've actually seen a few events here in the news in the last 4 months or so. These individuals, you know, typically an insider threat does not wake up one day and say, I want to cause harm to the United States government. Typically, there are indicators that take an individual down that critical path to becoming an insider threat, which is why early intervention is extremely important. If we're able to identify indicators and maybe help that individual get back on the right path, or take those circumventing measures to ensure that we're not placing our facilities, our technologies, our programs, and our information and people at risk, that's really, really important. So really want to look at those patterns of behavior, risky behaviors that are all often indicative of somebody that's moving down that pathway that we don't necessarily want to see them going.
That's interesting. Rob, what recommendations do you have for obtaining buy-in from department or agency lawyers opposed to or not completely knowledgeable of insider threat program efforts?
That's good, and that's kind of common. So insider threat and insider threat as a legal field is kind of a new niche topic, but it's not, I mean, it has its analogies to other national security fields or administrative law. I mean, we do this stuff all the time. We just don't necessarily realize what we're doing. I think it comes down to education. You know, I have a different background. I started as a legal career as an Army JAG, but before that, I was an infantry officer and did a stint as a Ranger Intel officer. You know, I have an operator focused mentality. I think it might be different some other folks who kind of grew up in the legal field. Really just take the time to educate the lawyer, make them right seat, left seat with the operator. This one's going to make folks kind of queasy sometimes, but get your mission brief and make your lawyer give it. You know, if your lawyer can't give your mission brief as well as, you know, your operators can, you got a problem. You know, otherwise there's a really good opportunity for kind of education. So, you know, the CCITPF and even the A certifications that are out there, if your lawyer hasn't tried to take that and they're in an insider threat role, shame on them. I'll reiterate that these are the opinions of ourselves and don't necessarily represent that of DoD or the DAF. But get training like certain organizations like the International Association of Privacy Professionals. They've got a great privacy law training program that trains lawyers in the Privacy Act and information they collect. And I would say the other thing, don't let the lawyers stop you with saying the answer is no. Maybe a no, but, you know, I can't do this because the law says we can't. Fine. If it's ethical and moral to kind of change the law, we change the law every year. every year we have an NDAA that goes on the books that through process at a high enough level, we can get things changed, added, modified if it makes sense. So identify what the issue is, figure out who's the proponent, and get it changed if you have to.
Yeah, and I'll further foot stomp, the importance and the significance of the educational aspect. I've worked with a lot of lawyers in many jobs that I've been in my career, and Rob and I have a great working relationship where we do explore gaps or shortfalls within existing policies and regulations, and then we try to sit there and pick into our brains and figure out, okay, what's the appropriate way to tackle this? Does this make sense? And looking for that attack vector to try to figure out how do we change or how do we update that policy. But education is absolutely critical and key. There should be no single point of failure in any insider threat program, at least ones that are effective. You have your key players or your insider threat program personnel that really comprise and make up that team and that synergy where individuals are sharing information, identifying risk, and then trying to determine the appropriate mitigation action to take. Your insider threat program personnel include your lawyer, it includes your HR, your leadership team, your security team, all of those key players within your organization, all needing to come to the table, all needing to have a good, solid baseline understanding of what your program is, what it's designed to do, and be enablers to try to ensure your mission is effective in carrying it out. Have your attorney come and sit down and shadow with your operators. Have your attorney come and engage with HR, with security, with the other key players within your program to get that better understanding. As Rob mentioned, being able to provide that mission briefing, knowing that mission inside now, because if there's ever going to be an issue when it comes to the legality of what you're doing, the first person you're going to go to or the first person others are going to go to is likely going to be your lawyer. So you want your lawyer to be as educated as possible on the program to be able to speak to it intelligently, and also make sure you're staying out of jail and you're doing things within the confines of the law.
Perfect. I know we kind of touched on it already, but what expectations of privacy do individuals have that are subject to security and insider threat programs?
That's good. I mean, you answered your question with your question. It's all about privacy and a reasonable expectation of privacy. And now we have a two-part test on that. Just because I think I should be able to walk around the street naked and not get arrested because I thought I was private doesn't mean that that's one that society is going to recognize as reasonable. So, reasonable expectation of privacy, a subjective expectation that I personally hold, and then one that society is going to recognize as reasonable. It all starts with the Constitution for states and federal governments. For industry, I would be careful too. So just because the Constitution doesn't apply to you, all the states have a state law invasion of privacy on the books. So kind of going back to where we were in the beginning, it's all about consent. You get around an interest of privacy by them consenting to you monitor. So make sure that your banners are up to date, that they've acknowledged that they know you're going to monitor, and then you record that information and then you audit. If you've got cameras up in the workplace, make sure that they're where they're supposed to be, where folks have no reasonable expectation of privacy. If you have them in the shower rooms or you have them in private offices, you're going to have an issue if somebody finds them and starts, complaining because you've obviously invaded somebody's privacy at that point. So talk to your lawyer.
Yeah, and I'll also add too that, individuals with a security clearance, they're held to a different standard, and in many cases, a higher standard. You think about when you log on to an information system, clicking that warning banner that indicates that you're subject to monitoring. Think about the standard form 86 that you complete and the various release forms that you complete when you're subjected to a background investigation that's going to look into whether or not it is in the interest of national security for you to hold a security clearance where you may access classified information. There is that higher standard with respect to our clearance holders because we are entrusting these individuals with our nation's secrets. So I'll just, I'll mention that, but I'll also caveat it by saying everyone still has that certain level of, or expectation of privacy. And piece of that is ensuring that identity resolution is in place within your organization. It is absolutely critical with respect to the insider threat and insider risk mission and what you do. You have to ensure that you are looking at data points or information involving the person that you believe it is involving. And you have to do your due diligence in order to ensure you've got the right person, because you are dealing at times with individuals' careers and livelihoods, and you want to definitely take a pause and make sure that you have repeatable, defendable, ironclad processes in place that at least give you the preponderance of the evidence and have resolved identities accurately to ensure that if you're talking about a John Doe and you're relaying risk information associated with that John Doe to that individual's chain of command, that you've got the right John Doe, and you're not talking about John Doe II that may have the same birthday but a different social security number, because that can have significant ramifications on an individual's career.
That's a great point. All right. So what do you do if you come across a media report or information that may be unvalidated or uncorroborated? Is it considered acceptable practice, for example, to mine data breaches to identify risks to an affiliation or affiliations to your organization?
I will say that, at least the second part of the question, the DAF Counter Insider Threat Program does not have the authority to kind of go out into publicly available information and start looking at stuff prior to us having an insider threat predicate. We derive our authority to look at publicly available information that might be protected by the Privacy Act by virtue of us conducting that national security type of investigation. So, but to your first point, generally speaking, if data is publicly available, it's fair game. That being said, we can't enlist third parties or vendors to go out and illegally obtain data that we can't otherwise get ourselves. But, you know, once information is out there for insider threat purposes, it would be imprudent for us to avoid looking at information and burying our head in the sand, especially if it is information might be related to an insider threat indicator.
Yeah, and I'll add that, you know, Rob and I work very closely within the Department of the Air Force to actually put processes in place related to this specific topic. So what I mean by that is, you know, there is information that becomes available in a news article, in the media. And what we don't want to do is, you know, turn and look the other way and just outright ignore it. But we also don't want to just accept it at face value as the truth, because as we know, you know, the media does get things wrong from time to time. But we have to be careful that we don't, you know, chase the rabbit down the hole every time there's a media article where information comes out, and now we're diverting our attention and our resources to chase this down to see if we have any risk or any equities where we may have to take some action. So really, you know, organizations should ask the questions and do the analysis. Take a look at the information on the surface. Who's the source? How is it discovered? How credible is it? Has anyone, to the best of your knowledge, validated it? Are you accepting it at face value? And what are your existing resources to apply to the matter? If you have the bandwidth and the ability, it may make sense to dig a little bit deeper and take a look at it. But if you don't, you have to make a judgment call, at least from a leadership perspective. That's something that I've done numerous times, where we come across information, it's elevated to me, and then I'm making a judgment call based on the totality of the evidence and our available resources and the amount of perceived risk to the Department of the Air Force. So taking that risk-based approach when information on the surface seems uncorroborated is going to be really, really critical, because it's going to keep you from continuously deviating off the beaten path to chase down anything and everything you come across.
That's perfect. Many states and jurisdictions have different privacy laws. How do you address contradictory positions related to data privacy, especially when it comes to government employees, unions, contractors, et cetera, that are geographically dispersed?
Again, talking about state-specific privacy laws, at least now, the 8 states that have them on the books are all related to consumer privacy. So it wouldn't necessarily impact the U.S. government pertaining to its individual employees within the state. I would just say that, you know, on a broader topic, you know, when developing the insider threat program for your organization, you have to ensure that the policies, the process, and the investigations are carried out in a manner that's, as John said, repeatable. the courts will generally defer to executive branch organizations when conducting its own activities within its purview when it's obvious to the court that the agency is not acting in an arbitrary and capricious manner. And that's critical, and I want to touch on that. Counter-insider threat, it is kind of a new niche area. It's not intelligence, it's not law enforcement, it's really broader than both. I would kind of look to the fact that counter-insider threat has kind of the largest authority, or the biggest area in which it can go look at information. So the DAF program has access to an unprecedented amount of information out there, and the ability to kind of go out and analyze risk and do really whatever John wants to do. Now, I go back to the not being arbitrary and capricious, because, you know, when I was a national security lawyer, I was in intel oversight, and I did constantly went back to kind of the church and the pike committees. You know, right now the pendulum has kind of swung from individual liberties all the way over to mitigating insider threat and detecting risk. I don't want to be the poor schmuck who does something that makes that pendulum swing all the way back. So repeatable process, not acting in an arbitrary and capricious manner, and making sure that we're going to pass that Washington Post test.
Yeah, and I know the question is about the geographical disbursement of personnel within an organization, but I want to kind of provide a different lens very quickly to piggyback on Rob's response and talk about the geographical disbursement of your program personnel. So your insider threat program personnel, maybe your HR component is in one location in the United States, your security is in another, and other entities are kind of spread out throughout the country. COVID and the COVID-19 operating environment taught us that we can really utilize an entire tool set of technology and capabilities out there, from doing a webinar like we are right now on Zoom, and reaching, you know, having far-reaching audiences really anywhere in the country, anywhere in the world. And you could do the same thing with your program personnel, pulling them in to have those frequent routine meetings and that established cadence where you're talking and you're engaging with those personnel to share information. So I know that's not really related to the question, but we do work in that type of environment in 2023, where even our program personnel are dispersed. So we have to make sure we're leveraging the technological capabilities that exist out there to be able to connect everyone and make sure we're sharing information in real time.
And I know we're running short on time, so I'll try and get this last question in. How should organizations think about employee consent for capturing data, specifically for the use of employment purposes? If we agree the purpose of monitoring is to reduce the risk, how can this data capture become its own risk to the organization, such as wrongful termination or discrimination?
Yeah, so consent, if freely given, you know, generally cures any ill. Make sure that the process for capturing consent is monitored, or you monitor. Let's make sure that you require consent for accessing information systems. So don't let them get on your system unless they've consented to monitoring. Record that and then audit yourself. This is also important, not just for the federal government, but also for industry, because as we discussed earlier, that state wrongful invasion of privacy lawsuit, even if you might not be breaking the Constitution, you still might find yourself paying a penalty if you invade someone's privacy. And I'll add, you know, lots of folks are lawsuit averse. You know, document. If an employee's acting out, start documenting it, start communicating it to them, start giving them that due process. Don't shy away from, you know, taking action and terminating a problem employee just because you're afraid of a lawsuit. I've personally witnessed the just organizational detriment that happens from tolerating toxic employees because you were too afraid to fire them. So yeah, have the courage to do the right thing. Just make sure that you brought your lawyers in, labor law stuff in early, and make sure that you keep that stuff documented for why you're doing what you're doing. Progressive discipline.
Rob, that's spot on with that assessment. I couldn't agree more. And being deliberate, taking your time, getting things right. We've talked about that a little bit over the last half hour, especially when you're rolling out those new requirements and those new processes. You have to be agile enough as an organization and as a program. You have to be responsive to new requirements. You have to be responsive to new technologies. But be careful and be deliberate when you roll those things out. Pause, take a knee, conduct an after action review, figure out what worked, what didn't, make those tweaks. fine tune the process and make sure that you're rolling it out and you're getting it right and you're building something that is repeatable and defendable. And then once you've gotten to that point, don't deviate.
Gentlemen, that's perfect. I think that's all the time we have for today. We're right at the top of the next hour. So I want to take this time to thank you both for your expertise on this subject. And with that, we'll try and address any questions in the chat through email. We appreciate you guys taking the time out again, and everyone have a great day.